Hi, everybody. Tim Zerillo here from Zerillo Law Firm. And Steve Sweatt and I, who's an attorney with Zerillo Law, we're talking about what we might do in the midst of the COVID-19 pandemic to help people answer some of their questions as it relates specifically to criminal defense topics. So what we talked about was how various different systems, the state system and the federal system, are each reacting to the pandemic, what they're doing, and just some practical ideas if you are facing a charge in state or federal court in the state of Maine, or if a loved one is, about how this virus is generally affecting the criminal justice system. So I have with me today, as I said, my associate with Zerillo Law Firm, Steve Sweatt, and we're going to talk about a few things, starting out specifically with the state system. And Steve, why don't you give us an overview right now as to how the state jail and prison system is handling COVID-19?
Sure, thank you. So at this point, the jail system, they're reducing the amount of prisoners that are locked up in the jails statewide. At this point, the Department of Corrections has released approximately 20% of the inmates, especially inmates who have less than 2 years left on their jail. They're being considered and released on home confinement.
So, Steve, is that for inmates who are not just in the jail system, but in the Department of Corrections, the prison system in the state of Maine?
Yes, yes, it is. Each jail, each county jail is assessing whether they're analyzing every inmate. They're determining if home confinement would be available to them.
And are there specific guidelines as to what inmates might qualify for home confinement, or is it really up to the warden or the sheriff of any particular jail or Department of Corrections facility?
Well, they're actually the Department of Corrections and the jails are actually communicating with the district attorney's office, and they've determined that people who have been charged and have been in jail for nonviolent offenses and people that are at higher risk of contracting a serious case of coronavirus, they've determined that those types of people will be more likely to get the home confinement and to be released.
All right, so we're in a situation now where the state courts are effectively closed until May 1st, and then whether or not they're going to reopen on May 1st, we do not know. That'll be up to the judiciary and Governor Mills. In the interim, how are the state courts handling bail determinations, and is that still happening, and how is that happening, if you would tell people?
Sure. Yeah. So it's definitely the pandemic has definitely made this bail hearing procedure a lot more complicated. There's currently one lawyer of the day at the courthouse taking in clients who are obviously at risk of jail, but with people who have hired an attorney, they're doing video conferencing to reduce the spread of coronavirus.
So the lawyer of the day system you're talking about is a system related to court-appointed cases or people who don't have private lawyers when they're first brought in. But you're saying if you're privately hiring a lawyer for a case in which you've been charged, even while the jail is closed, those bail hearings are being heard via video conferencing, is that right?
Exactly.
Okay. All right. So thank you for that. Why don't I give you, why don't I give a little update on the federal system, since Steve has covered the state system. The Bureau of Prisons, is the federal prison system, for those of you who are not familiar with it. So if you have somebody who is a loved one who is already in the Bureau of Prisons, you might have heard them ask about how can I get out of here with this pandemic, starting to march on. And I'll see if I can share my screen with you, and just to give you an idea as to what the Bureau of Prisons has going on right now. And you'll see as you see there, that increase, and it might be, we might be blocking it a little bit, so I'll try to move us over here. But you'll see there that there has been a spike since March 19th of 2020 of positive inmates in the Bureau of Prison System and the number of positive staff. Now, so the curve, and this is through April 10th. So the curve here, as you've heard about flattening the curve, obviously, in our communities at large, but the curve is not flattening in the prison system. And it doesn't matter whether you're in a state prison system or a federal prison system. These prisons and jails are petri dishes to begin with. And the reality is that if you take a highly contagious virus like COVID-19, where people cannot socially distance between 6 feet of each other, it's just going to spread. And so that's why you have seen forward-thinking jailers and wardens try to get people out of those jails when they can. Now, the process for getting somebody released is a little bit cumbersome in the federal courts. The first thing you would do is you would file a motion for, or you should file a request for compassionate release from the warden of whatever Bureau of Prisons facility you are in. That facility, technically, you are supposed to exhaust that administrative remedy before you can file a motion with the court. Now, all that being said, filing a motion with the court, there are some people that are being more aggressive about it, even if their 30 days have not passed, since they requested in writing that the warden release them, and they're filing the motions anyway before that 30-day period is up. And sometimes that's necessary because of the fact that your circumstance might be dire. Perhaps you have you're already compromised, immune compromised, or you're an older individual, et cetera. So, and judges are, depending on where you are in the country, judges are treating requests for compassionate release before the warden has taken his 30-day period. They're treating them they're given disparate treatment depending on where you are. In Maine, I'm not aware of a case so far in which the federal court has allowed a case to go forward in which there was no exhaustion of the administrative remedies. The worst that'll usually happen, though, and in the Third Circuit, I know the government has conceded that there can be a waiver of that exhaustion requirement. The worst that'll happen is you would file your motion. The court would likely, if they were going to require you exhaust your administrative remedies, would likely deny it without prejudice and allow you to refile when the 30 days are up. Even so, there is certainly an argument that we shouldn't be waiting around for people who have some significant health concerns and are immune compromised. So that's what's happening in the federal system. If you are arrested now or facing arrest in either state court or in federal court, there is a real argument that a real enhanced argument, depending on your personal circumstance, that you may be eligible for bail, or in federal court we call that release from detention. Now, in the state of Maine, they have not so far released anyone from detention, just based upon the argument that we have this pandemic. But if you are already immune compromised, if you already have a health condition, maybe as a result of age in combination with the factor of the pandemic, you may have a better argument. Now, release from detention in federal court is not always easy. It depends upon the charge, and there are rebuttable presumptions in some charges, et cetera. And that's way longer than I intend to spend for this particular video. In fact, we've probably already made it long enough. Steve, anything else you wanted to add to what I just said?
I think you've elaborated on very well. It's the scenario in state court, if you've had your bail hearing at an arraignment or your initial appearance, the bail code allows you to revisit the bail and have a new judge issue your bail conditions or new bail conditions or a new bail amount. And you use this argument that a combination of the pandemic, your severe, for example, severe health conditions such as asthma or even diabetes, and you make this argument to modify your current bail conditions.
Okay, great. So that's something that people should consider. In other words, what Steve has very well said there is that you can get a second bite at the apple sometimes. And if your bail was denied maybe before the pandemic and you're still pre-trial, sitting there waiting to go to trial, you may get another bite at the apple where you can combine the pandemic with your own risk of harm if you are older, if you suffer from health conditions like heart disease, diabetes, asthma, you're immune compromised, etc. So that's something to consider. Thanks. Well, thank you for watching. I hope this is helpful. We are, as essential workers, lawyers are still trying to work safely and smartly throughout this crisis. And obviously, we realize that justice never sleeps, and the reality is that people are still getting arrested, and they still need legal representation. So we hope this will help you if you or a loved one are in that situation, or if you're just curious as to how this is working. So thanks for watching, and obviously, if you need anything, give us a call at 207-228-1139 or visit our website, which is ZerillowLaw.com, ZerillowLaw.com. Thanks for watching.